Hi, my name is Ben Sheffner. I'm Vice President of Legal Affairs at the Motion Picture Association of America, and welcome to our presentation about the next great Copyright Act, the copyright review process. Just to give a little bit of introduction, as I said, I'm an attorney at the MPAA. I work mostly in the area of copyright policy, although I should say that as far as this presentation goes, I'm not speaking on behalf of the MPAA. These are my own views. With me today is Chris Reed, who will now introduce himself.
I am Chris Reed, Senior Counsel for Content Protection Policy at Fox Entertainment Group, and where I work on copyright policy issues related to the protection of Fox's creative assets. And like Ben, the views I express today are personal and not those necessarily of the company.
Great, so let's go ahead and get started. As I mentioned, the topic today is the view from Washington, the next great Copyright Act and copyright review. So we're going to be talking to you about the process that's been going on mainly in Washington over the last several years, looking at whether it's time essentially to legislate in the area of copyright. So where are we now? Looking back at the last almost 100 years of copyright law, it's actually been relatively stable. If you look at the timeline, you see that in 1909, Congress completely rewrote the Copyright Act. And then for a period of 67 years, there was not a whole lot of activity until they passed an entirely new Copyright Act in 1976, which is, of course, 39 years ago as we speak today. Now, in those 39 years, there's been a number of specific amendments to the Copyright Act, some big, some small, some very consequential, some not so much. But essentially what we have now is the 1976 Act. I should just mention that I would say the one kind of most significant revision of the Copyright Act since 1976 has been the Digital Millennium Copyright Act, passed in 1998. It's sort of the dawn of the commercial internet to try to deal with issues related to copyright infringement on the internet. But again, that's probably the one very significant substantive change to U.S. copyright law since it was completely rewritten in 1976. So I'm going to pass it on to Chris now. He's going to talk about this new call for potentially rewriting the copyright law.
Yeah, so thanks. I think to best understand it, you need to go back a little bit and understand the context. So Maria Palante was appointed register in an acting role, or on an acting basis rather, back in January of 2011 following the retirement of Mary Beth Peters in December of 2010. She had served in the role of register for about 16 years. And Maria was no stranger to the Copyright Office. She had worked with Mary Beth Peters as a senior policy advisor for a number of years, and then most recently, prior to being appointed register, was the associate register for policy in international affairs. And prior to that, she worked at the Guggenheim Museums and was an attorney at both the Authors Guild and the National Writers Union. But when she took office in January of 2011, she embarked immediately on a fact-finding mission to really get a sense of what the stakeholders were thinking, both internally and externally. So she was looking both at internal stakeholders within the Copyright Office, the employees and the administration, as well as the external stakeholder community to get a sense of what the issues were facing them both with the office and with copyright policy generally. That led to a document called the Priorities and Special Projects document in October of 2011, which was sort of a way of telling the community, we hear you, there are problems, and we need to address some of those. And then a little over a year later came this speech at Columbia Law School in New York called the Next Great Copyright Act. And as the name implies, she was really calling for a wholesale look at the Copyright Act, the current provisions, and whether they're serving the copyright marketplace today. She literally encouraged Congress to, quote, think big, and went through, the beginning of that speech really went through the history of copyright law in the U.S. and talked about prior general revisions, such as the 1909 Act and the 1976 Act that Ben talked about a moment ago. And really was interested in getting a conversation started about copyright law and the way things are evolving in the United States. And the speech was lengthy and very detailed, and the speech was given at Columbia and then subsequently published in one of their law journals. And she called for review of a number of areas, including, and I'll mention a few of them. You see a few on the slide there, but I won't go through all of them. But there are a number that we can talk about here. One, a big one, orphan works, has been a big issue for the office for a number of years, including back to the Mary Beth Peters days. These are situations where works that are in copyright, where you can't can't find the owner, identify or locate the owner so that somebody can make a productive use of that work. That is something that's been on the minds of many copyright policymakers and certainly on the mind of the Copyright Office. Another is small claims solutions for independent artists, for the most part, independent creators. And this is emerging as a theme in Maria's tenure, actually, a real interest in making sure the Copyright Act works for the independent creators and people other than the major stakeholders that we often hear about in copyright policy discussions. And then I think the other thing that's worth really mentioning here is the focus on exceptions and limitations. Maria's fond of pointing out that copyright is not absolute and that it is, there are certain socially desirable uses where we may want to set up compulsory licenses or some sort of exception or limitation. And a couple of areas where that's really taken center stage is Section 108 exceptions in favor of libraries and archives, and Section 121 of the Copyright Act involving the visually impaired community. A lot of those provisions are very dated. They date back to the analog era, and are very difficult to sort of figure out how those work in the digital environment.
So, Chris, let me ask you. She gave this, very comprehensive speech. She called it the next great Copyright Act. So, did she literally mean sort of tearing up the 1976 Act and starting over with a blank sheet of paper, or making limited revisions to the existing Copyright Act, or something else?
So, I think on some level she actually was really interested in doing what you just said and setting up a brand new Copyright Act and starting fresh. And that's why I think she marched through the way some of the prior acts were drafted. The 1909 Act and the 76 Act really were sort of start over and look at basic principles. I also think she recognized that was probably unrealistic in the current climate, and really wanted the speech to be a provocative conversation starter. And I think in many ways she succeeded, which I think is a great segue. She gave Congress sort of a list of things to think about. What's Congress been doing with that?
Sure. So after Maria gave this speech, which actually surprised a lot of us in the copyright community, it's kind of a major development in our field to say, hey, we might get a brand new Copyright Act. So what happened? Obviously, the Register of Copyrights doesn't have the power to unilaterally write a new copyright law, or certainly not to enact one. That's the job, obviously, of Congress. So what did Congress do? So the slide you're looking at is Bob Goodlatte, who is the chairman of the House Judiciary Committee. He's a Republican from Roanoke, Virginia. He's an attorney and interested in copyright, a supporter of copyright. So what did he do? He obviously heard about Maria's speech. I don't know if he actually read the entire thing, but certainly was briefed and talked to Maria about it. What did he do? Did he say, you know what, she's right, we ought to have a brand new Copyright Act? Not exactly. Not exactly. So about a month or so after Maria gave the speech, Chairman Goodlatte put out his own statement. And one thing that's, what he said, it's my belief that a wide review of our nation's copyright laws and related enforcement mechanisms is timely. Therefore, the Judiciary Committee is going to have a series of hearings. Now, it's really important to focus on the word review. He did not say out of the gate, we're going to reform copyright law. He says we're going to review it. We're going to take a close look at how it's working almost 40 years after the last major revision, and then we'll decide what to do at that point. But again, he did not immediately say, yes, it's time for a brand new Copyright Act. So he followed through on his word. From, say, mid-2013 to actually within the last several months, the Judiciary Committee held a series of 20 hearings. I believe they heard from 99 different witnesses, people with a wide variety of views on copyright, people who want stronger and harsher enforcement to those who think copyright law is terrible and it should be pared back considerably. And as you see from this list of topics, sort of ran the gamut of copyright issues. They almost sort of started with Section 101 and marched through the entire Copyright Act section by section. Some of those will be very familiar to those who are watching. Things like fair use, or the DMCA safe harbors, or the term of copyright. Some are more obscure. I mean, at heart, this is a political process. Congress is a political body. It's not a bunch of academics just sort of sitting around deciding, what would be the platonic ideal of a perfect copyright law. And just one example of that, you'll see there's actually a sub-bullet for building codes. And you would say, what in the world does that have to do with copyright? That's not sort of the thing that people like Chris and I deal with day to day in our jobs. But there was some constituent who had gone to his or her member of Congress and said, you know what? I think it's unfair that when I want to access, say, the plumbing code that applies to my city, I need to pay for it, because those plumbing codes were adopted or sort of promulgated by a private body, which spent probably millions of dollars to do all the testing, came up with a proper code, and then they were adopted by a particular city. And if you're a plumber in that city, you need to obey them. And he said, you know what? It's not fair that I have to pay to access those. So the committee spent several hours on that topic. I'm not saying it's unimportant, but it's not the kind of thing that most people who work in the copyright world think about day to day. Just again, a reminder that politics plays a significant role in this whole process. So again, over the period of about 2.5 years, 20 hearings, 99 witnesses, a very, very comprehensive review. And again, that was all in the House Judiciary Committee. Of course, the House can't enact legislation on its own. There's another body on the other side of Capitol Hill, the U.S. Senate. The bottom line with the Senate is they have done little to nothing on copyright review. The Judiciary Committee in the Senate did not say, hey, we're going to review copyright law. They have not held a single hearing on this topic over the last several years. There have been, though, there is a significant development within the last several weeks, actually. The chairman and ranking member of the Judiciary Committee, that's Chairman Grassley and ranking member Leahy, wrote a letter to the Register of Copyrights, which is a common occurrence, requesting a study on a particular topic. And the topic is software that is embedded in sort of everyday devices, whether it be cars or refrigerators or toasters or pretty much anything these days has a microchip on it with software on it. And asking the Copyright Office to review the implications of having this software in your devices. And they asked for a report by December 15th of 2016, approximately a year from now. And that's a big topic that I'm sure will get bigger and bigger in recent years. But again, the bottom line with the Senate is that they have not really sort of taken up the baton of copyright review at this time. Now, the Congress isn't the only player in this area, and Chris is going to talk about some of the other government bodies that have been engaged in the copyright review process over the last couple of years.
Yeah, so talking about the Copyright Office study that the Senate asked for is actually a great transition, because one of the things the Copyright Office does is serves as the primary advisor to Congress on copyright-related topics. And the way they do that is engaging in a variety of public processes to get a sense of what stakeholders' views are on various issues, and then publish reports. And in many cases, those reports include legislative language, proposed legislative language. And you can see on the slide there that they've been busy, just like the House has been busy. Again, not going to go through all of these, but wanted to point out a few of them. Orphan Works, again, makes a big appearance. They published a document back in 2006, I believe it was, and then again just this year in 2015, sort of updating it given recent developments involving mass digitization projects such as the Google Book Search matter. And again, Small Claims makes an appearance. That's one of those studies where they actually drafted a bill and proposed legislative solution, creating within the Copyright Office a small claims tribunal that would hear cases involving relatively minor damages, cases involving copyright claims that are really not worth enough to justify bringing full-blown federal litigation. We see that issue a lot with visual artists in particular, where the value of any one particular image is generally pretty low, but the infringement is nonetheless real and offensive to those photographers who were infringed, and so they really are looking for a solution, and that's something the Copyright Office has been focused on. They've also been looking inward at some of the issues they have on their own, and I'll point out two of those: the DMC agent situation, the registration database for notifications of claimed infringement that go to online service providers under Section 512 of the Copyright Act. The Copyright Office maintains a database of who you're supposed to send those notices to, and right now it's literally just a form you fill out and send to the Copyright Office. They scan it and put it on a website. It's not searchable. Those forms sometimes mysteriously disappear off of the Copyright Office website. right? And so they have been working for a number of years now, actually, on a database to facilitate that, and they've gone out to the public and to stakeholders and asked exactly what that database should look like. Strikes me as a fairly straightforward project, but they've been taking their time with it. The other thing that needs attention at the Copyright Office is the recordation system. Sort of functions as it's a companion to the national registration system that the Copyright Office operates, and together it sort of serves as the registry of deeds of copyright interests. And when you record an interest right now at the Copyright Office, it can take up to 2 years to get a certificate of recordation back, because like the DMCA agent registration system, it's primarily paper-based, and so the office is literally scanning in documents and sending them back to you. It's not automated at all. It's very expensive, and so they have been going out to stakeholders to get a sense of what that system should look like as well. Music licensing is also considered often sort of low-hanging fruit in the copyright policy space, largely because I think it's fair to say everyone agrees something should be done there. Not clear everyone agrees on how to do it, but the Copyright Office, the general counsel there, presently Jacqueline Charlesworth, has a lot of music industry experience and spearheaded a report on the music licensing landscape. And it's really, to my knowledge, it's the first time anybody has endeavored to really catalog what's going on in that world and kind of look at the major issues. And like many areas of the Copyright Act, the major issues stem from the fact that the way music is created and the way it's distributed is very different than it was when those sections of the Act were first drafted.
So, Chris, let me ask you about this. So the Copyright Office does these reports, and they're very comprehensive. They have very smart, experienced lawyers doing them. They're really, really well done. But again, the Copyright Office doesn't make law itself. Right. It's essentially an advisory body, where one of its roles is to serve as an advisory body to Congress. So what happens to these reports once they issued? Does Congress sort of automatically take them up and do them, or do they sit on a shelf somewhere, or how would you say they're generally received?
So they're generally well received, but they also generally sit on a lot of shelves, I suspect. So they are distributed to relevant members of Congress, members of the House Judiciary Committee, and in some cases other relevant committees. But as Ben just said, they can't do anything. The Copyright Office has no authority to do anything on its own. It's really, it almost becomes a lobbying effort on behalf of the Copyright Office to members of Congress to get them to take up specific issues. Some of this is an anticipatory game by the Copyright Office to kind of get a sense of where Congress is going and what they might be interested in and anticipate the questions they're going to have. And I think that's what they were really doing with music, was they kind of had a heads up that was an issue frustrating a lot of stakeholders. Congress was hearing about it. They put together that report in anticipation or expectation that Congress may take up that issue. We still don't know if they will, but that's, I think, really what drives a lot of the topics that the Copyright Office picks outside of when they're asked to do a specific study. So changing gears and crossing the river, over at the Patent and Trademark Office, which despite the name actually does have a small copyright shop in their Office of Policy and International Affairs. Their role, whereas the Copyright Office's role is to advise Congress on copyright-related issues, the Patent and Trademark Office, being part of the Commerce Department, its role is to advise the administration and the president on intellectual property-related issues and copyright issues, and really to help the administration form its administration view on these issues. And they've been busy as well. In 2013, they issued a green paper addressing 3 topics, including digital for sale, statutory damages, and remixes, the idea of people taking existing copyrighted works and remixing them in interesting ways and creating new works. And they also were looking at issues relating to the DMCA notice and takedown system and improving the efficiency of that. And that resulted in a statement of best practices by a number of stakeholders following a public process that was convened by the PTO under this sort of green paper rubric. That is now on the PTO website and has been released. The white paper that follows from those green paper topics I just described, we're expecting sometime in 2016. Unclear what that's going to say, unclear whether that's going to result in any kind of legislative recommendation. And it'll be interesting, your question a minute ago about what happens with Copyright Office studies is also interesting in this context because, of course, the Copyright Office is statutorily obligated to advise Congress, whereas the PTO is advising the administration and has no real direct line to Congress. on these issues. So whether Congress takes the PTO up on any recommendations it may make also.
But the recommendations coming out of the PTO, those are the official pronouncements of the administration,
that's right.
Correct?
Yeah, that's right. Yeah, so it would be sort of what the Obama administration thinks about the digital for sale statutory damages and remixes questions. So like I said, we expect that sometime in 2016. Really have no sense of timing. I know things, just from having worked in the government for a while, I know things can take a while to go through all the clearance process that needs to take place in the executive branch. So that's a look at what's going on the government side. And Ben, do you want to tell us a little bit about what's happening with the private sector?
Sure. So all the things that Chris and I have been talking about the last few minutes, all of the different sort of review processes going on in various bodies throughout the government, they don't just sort of do this on their own. They're taking in input in a variety of ways from players, again, across the copyright spectrum, whether people from industry, individual creators, academics, I should say industry sort of on both sides, on the copyright owner side, creator side, as well as the sort of user/distributor side. So let me just spend a couple minutes just sort of giving the general landscape of who the major players in this debate, in this review process are. If you take a look at the slide, we basically have this divided into three buckets: the upper left, the upper right, and then those at the bottom. And we'll just spend a minute or two on each of them. So at the upper left, we have the major copyright owners, creators. That's as I mentioned, I work at the Motion Picture Association. We represent the 6 major motion picture studios here in the U.S. It also includes the major record labels, the music publishers who represent songwriters and composers, AAP, which is the Association of American Publishers, that's the book publishers, Copyright Alliance, which is sort of an umbrella group for all of us, the Business Software Alliance, which represents major software owners, and then a new player you wouldn't necessarily think of big copyright owners, but have actually become quite a significant player over the last several years, which is the Entertainment Software Association, in other words, the video game makers and developers. So in general, that group wants strong copyright protection for their works. I think it's very important to be able to incentivize, finance the development of all these new works, and they don't want to see an erosion of copyright law. In fact, in certain instances, they want it to be even stronger. Then in the upper right quadrant, you have the major players who would, in general, like to see the major institutional players who, in general, would like to see narrower or weaker copyright protection. And those are generally the big internet companies like Google and Amazon. You have ISPs, Verizon, AT&T, et cetera. They don't want to be held liable for copyright infringement that may go on in their networks. You have major consumer electronics manufacturers represented by the CEA, the Consumer Electronics Association. And then you have groups like libraries who, of course, would like to be able to do all sorts of things with works that copyright owners would generally like to be paid for if they're going to be used in those fashion. Then at the bottom, you have groups that are described generally as either public interest groups, sometimes referred to as copyleft, sort of a play on words of copyright. Groups that would like to see, again, a narrower or weaker copyright law. Most prominently, the EFF, the Electronic Frontier Foundation, Center for Democracy and Technology, and Public Knowledge. And I say these groups are overwhelmingly aligned with those in the upper right, the sort of major distributors, internet companies, consumer electronics manufacturers, who in fact are generally the funders of these organizations. So what is the position that these various players are taking in this copyright review process? We on the copyright owner side said, you know what? Yes, it's a good idea to take a look and see how the Copyright Act is working out after almost 40 years since the 1976 Act. But we recognize that copyright today is a politically fraught area. It's not fraught so much Democrats versus Republicans like most things are in Washington, but there are very strongly held opinions and very sort of divided opinions about whether copyright law is doing a good job and in fact appropriate in the internet age. So we on the copyright owner side have not been out in front saying, you know what, it's time to tear up the 1976 Act and start all over. is entering into voluntary initiatives between copyright owners and then various of the distributors, the users of copyrighted material, in order to combat piracy. Several examples I'll list really quickly. One is called the Copyright Alert System, which is a collaboration between the major movie studios and record labels and the major ISPs, where the copyright owners will send notices to the ISPs, which get forwarded on to the users, the users of those ISPs and subscribers who are engaging in infringement of movies and television shows and music over peer-to-peer networks like BitTorrent. We think that's working fairly well. It gives mainly an educational program to let people know that they shouldn't be engaging in this kind of thing. Chris mentioned a minute ago, the USPTO convened this meeting of all sorts of stakeholders, including groups like ours and all the other ones that I just listed a minute ago, about how to improve the DMCA notice and takedown system. And then there's also ongoing initiatives with advertisers and payment processors who may be providing services to pirate websites. So we are working with, for example, on the advertising side, it's a very complicated ecosystem of how ads get served on websites. But we are working with everyone from the brands who advertise, to the advertising agencies, to the placement services, the ad networks, and all sorts of other players within that ecosystem to make sure that these ads don't get placed on pirate websites and sort of fund their illegal activities. Same thing with payment processors, whether it's major credit card companies, internet payment companies like PayPal, etc. So that we think there should be a big focus on voluntary initiatives. Music licensing. It's not exactly our issue on the motion picture side, but there is a consensus by all players on the music side, I think, that the current system is broken and needs fixing. Now, there is no consensus, I should say, on exactly how to fix that. And we know what we're talking about is things like, what are the rates that internet services like Pandora and Spotify should pay for use of music? They say they're paying out way too much. The songwriters say they're getting paid way too little. But essentially, this is a battle over money and sort of how that pie gets divided up. There's other issues such as whether pre-1972 sound recordings, which are currently not protected by federal law, although they may be in some cases by state law, whether those should be sort of brought within the federal system. And then the last issue where we think there actually is another good chance at consensus and a good chance that legislation could actually be enacted is what we are calling Copyright Office modernization. And let me just explain briefly what that is. Sort of two aspects to it, and Chris touched on this a minute ago. The first aspect is sort of purely kind of operational, and this is pretty mundane stuff, but everyone recognizes that the Copyright Office's IT systems, their databases, their search capabilities are not up to modern standards. I mean, you go on their website and do a search, you feel like you're on the internet back in about 1997 or 1998. It's just not really sort of modernized. Everyone recognizes they need better computers. They need more IT staff. They need to really sort of step up their game on the IT side. Chris mentioned the recordation system, which was instituted in the 1870s on paper. Here we are in 2015. It's essentially still the same. There's a few tweaks. They've made some baby steps into the electronic age, but it's basically still all on paper. It takes over a year for your recordation papers to get processed. So the recordation system, which Chris referred to a few minutes ago, it was started in the 1870s entirely on paper. Here we are in 2015, still almost entirely on paper. They've made a few baby steps into the electronic age, but everyone, and it still takes over a year to get your papers processed by the Copyright Office. Everyone recognizes, again, the Copyright Office needs to sort of step up its game on the sort of practical aspects of sort of running a modern government agency.
And I'll just mention, from having worked there for a few years, that I think a lot of the frustration, both internally and externally, staff aren't happy with the way that system works either, is that a lot of the software they use was built for the library. So it was built with library functions in mind, because it's part, the Copyright Office is part of the Library of Congress. And so a good example of that is the search that you just mentioned. The copyright records of the National Copyright Registration System exist in an instance of the same software that the library uses to make books and other library resources searchable for patrons. And it just does not fit. And so a lot of the questions going on now in the context of this modernization discussion are about whether and to what extent the Copyright Office and the library should be as intertwined as they are now. There's some compelling historic reasons for that and why that was set up that way, but it's not clear that those reasons are still valid today.
All right. So as I mentioned, Copyright Office modernization has kind of two buckets or two categories. The first is the sort of operational stuff. And I think there's wide consensus that, again, the Copyright Office needs to be sort of modernized in that in that aspect. The second bucket is a little bit more controversial and a little bit more interesting, at least for sort of copyright and constitutional geeks like us, which is, so the Copyright Office is a little bit of an odd duck within the federal system. It's one of its major role is to administer the copyright law. Now, most agencies that administer the law are in the executive branch or independent agencies, things like the Federal Communications Commission or the Securities and Exchange Commission. Again, the Copyright Office is a little bit unique. So the Copyright Office is a division of the Library of Congress. So it's in the legislative branch, again, along with Congress. There are, as Chris mentioned, there's historical reasons for this, but there's a lot of people question whether this current arrangement sort of makes sense in the modern age, as copyright has really sort of become like a major part of our economy, really the driver of a lot of jobs and trade and economic growth, and that maybe it is no longer sufficient just to have the Copyright Office be a division within a much larger entity, the Library of Congress, that has its own interests that are sometimes not exactly in sync with the Copyright Office's role or interests. So there are proposals that have been debated and discussed over the last couple of years for essentially placing the Copyright Office somewhere else in the government org chart, essentially. One of the proposals on the table is to have the Register of Copyrights, who is currently appointed by the Librarian of Congress, to instead be appointed by the President of the United States and then confirmed by the Senate. And that would give her or him sort of some additional stature and some additional ability to do things like promulgate regulations by him or herself that is not currently permitted under the system. So the proposal that we and a lot of others have embraced is to, again, separate the Register of the Copyright Office from the Library of Congress, make the Register appointed by the President and confirmed by the Senate, and then have the Copyright Office existing as a freestanding agency still within the legislative branch. There's a variety of bills being discussed. One of the most prominent is called the Code Act, sponsored by Representative Marino from Pennsylvania, Representative Chu from here in California, and they have done largely what I just described. Although the bill, at least as discussed in current form, it's silent as to where exactly the Copyright Office should sort of sit within the government org chart. But again, they do favor separating it out from the Library of Congress. All right, so what are the priorities then of those on the tech or copyleft side? Several. They have some specific statutory changes that they, in fact, have said over and over that they favor. They want to limit statutory damages. They very much want to preserve the safe harbors that were passed in 1998 as part of the Digital Millennium Copyright Act. Those are in Section 512. They also want to address what they see as the problem of improper takedown notices. Copyright owners sending notices on material that's actually not infringing. So they want to strengthen what's known as Section 512F of the DMCA, which actually provides a cause of action for someone who feels that they've been the victim of an improper takedown notice. They want to limit secondary liability doctrines, which hold various service providers liable for infringement that is committed directly by their users. They want to reduce the role of international treaties, which they feel improperly sort of lock in a high level of copyright protection that they would prefer to lower through legislative means. They don't like Section 1201 of the DMCA, which makes it illegal to essentially hack digital locks on copyrighted works that make it more difficult or impossible in some cases to copy or access those works. And also they want to create what's known as a digital first sale doctrine. As most people are probably familiar with the sort of old-fashioned or the existing first sale doctrine, which says that if I buy a book at the bookstore, the copyright is essentially exhausted, and I can resell or give away that particular copy to somebody else. No one disputes that. How it applies in the digital area is different though, because essentially if I say obtain a digital file through a service like iTunes, that makes a copy on my computer or my iPad or my iPhone, and I can't just make another copy and to sell or give it away to somebody else. That in itself would be an instance of copyright infringement. So there are those, some, not necessarily all, but some want to sort of change the law to enable the resale, or essentially the copying of those digital files.
And one of the challenges for industries like ours is that when you create a copy, it's a perfect copy. And you have no way, with at least current technology, we have no way of knowing if the original copy has been deleted. And so it's entirely possible that you allow somebody to resell digital content and then that person resells it and that person resells it, and all of a sudden you've really got a bunch of downstream sales based on one original sale, and none of that money or revenue is flowing back to the copyright owner. And it's also very interesting in many of our industries because we take the position that we're not really selling anything, we're licensing it, which would causes first sale doctrine is not even triggered in those circumstances. So it'll be interesting to see how that one shakes out and what Congress does with that.
All right, so we've been talking for quite a while now about this process that's gone on over since essentially the spring of 2013. All these hearings in Congress and the Copyright Office and the PTO doing all these studies and holding roundtables and multi-stakeholder fora, which was a term that I had never encountered until I started interacting with the government. So they've been doing this, again, a very comprehensive review of current copyright law for the last 2.5 years, which is really, as we sit here in the fall of 2015, kind of winding down. So as this review process or this review stage draws to a close, what's happening now, Chris?
So Congress kind of summarized or concluded its hearing process or public input process, if you will, by going on what they called a listening tour. They had sessions in Nashville, Silicon Valley, and Los Angeles just in the past couple months where they had roundtables of people that for the most part were not able to testify in Washington. I think there was some overlap, and some of the folks that appeared at the roundtables during the listening tour had testified, but generally speaking, they were trying to get out and hear from the people, and they've done that. So now they've really heard from, I think, everybody. It'd be hard-pressed to say in the copyright community that we didn't have an opportunity to be heard at this point through the various things you've heard about today. So the Congress and the PTO and the Copyright Office process.
Just to interject for a second, it's funny. I mean, as Chris mentioned, so they've been doing these hearings in these various places to hear from real people in Nashville, real people and creators in Nashville and Silicon Valley in Los Angeles. And Chris and I have been at a lot of these instances, and it's really funny because we see the same people that actually show up at all the same things in Washington. I mean, you have there's a group of us, both on our side and the other side, and we all sort of hang out together, and either mostly in Los Angeles or DC. And again, these are largely the people that show up at these events wherever they're held across the country.
It's like many things, it's certainly a small world. I think you see the same folks over and over again, and just in a different city. So the Register actually was asked to give or to testify at both the first hearing during the congressional copyright review process and also the last hearing. And at the final hearing, she laid out in her testimony, which is part of the materials for today's presentation, she laid out a number of areas that she viewed as ready for the legislative process. And you'll see, again, some of them on the slide. They look suspiciously similar to the ones she laid out during her Next Great Copyright Act speech. But again, music licensing, small claims, orphan work, something we haven't talked about yet today, although I think has sort of widespread appeal among many stakeholders, is felony streaming. The issue with that is that presently it is a felony to engage in criminal copyright infringement, or it could be a felony to engage in criminal copyright infringement for violations of the reproduction right, but not for the right of public performance and display. And as our industries move more towards the distribution of content through streaming technologies, that's becoming more of an issue. It's harder to get law enforcement interest in pursuing cases involving unlawful streaming because it's only a misdemeanor. The Justice Department is on the record as supporting making that on par with the reproduction right crime as well. And so we'll see what happens there. Certainly there's industry support, again, the DOJ and the Copyright Office both supporting that. And then again, limitations and exceptions. The Chafee Amendment, which is Section 121 for the blind and visually impaired, is becoming a real hot issue, particularly in education, where students who are blind or otherwise print disabled can't access certain textbooks and things like that. The law presently allows you to create Braille versions of those books without permission from the copyright owner, but most students now don't learn Braille. So there's basically a literary crisis in the print disabled community. And then another interesting issue, you heard Ben talk a little bit about the Section 1201 anti-circumvention rules. There's a process that goes on every 3 years where proponents can assert the need to break or lawfully hack those digital locks that Ben described earlier. And right now it's such that you have to basically plead your case every 3 years. If you got an exemption during one cycle, you have to do it all again the next cycle, 3 years later. And there's a bit of a push, and I don't think there's a whole lot of opposition to this one, to make that sort of a rebuttable presumption, or at least renewable without a full record showing like you have to have now. And then, of course, Copyright Office modernization is something that the Copyright Office itself is very much in support of. And I just wanted to mention also, in addition to those topics you see listed as ready for the legislative process, the Register identified 3 other areas that she thinks are worthy of further study. One of those is a large study on the DMCA, so both sections 512, the notice and takedown and safe harbor system, as well as the anti-circumvention provisions of section 1201. Mass digitization, again, on her list of things to look at, despite the report that just came out this year. I think there's continuing issues in that space that will need to be addressed. And then lastly, moral rights, which is an issue relating to the integrity of artists' work and their ability to maintain some control over what's done with their work. Mostly comes up in the visual arts space, but also relevant in some other areas as well.
So, Chris, one thing that one sort of big copyright topic that we've barely touched on today, and I want to ask you about it, is fair use. So anyone who works at all in copyright or is even familiar with copyright knows about fair use. It's one of the sort of major limitations or exceptions to the copyright owner's exclusive rights. What have people been saying about fair use? Are there calls to sort of rewrite Section 107, which sets out those 4 statutory factors that we all know and love? What are people saying about what, if anything, Congress should do about fair use?
Well, to answer your question about whether people think it should be rewritten, not anymore. So for a while, many of the people in the user community that Ben was talking about earlier, the copy left, to use the general term, were very much in favor of trying to clarify fair use and get a better sense of what is and isn't permissible under those 4 factors. One of the challenges, of course, of fair use is that it's very fact dependent, and so you end up not really knowing if something is fair use until somebody tests it in court. The flip side of that is that it's very flexible, but the folks looking for clarity have since, I think, quieted down a little bit, because we've seen over the past couple of years what I would characterize as a pretty dramatic expansion of fair use by the courts. And so I think the copy left community is increasingly comfortable with where they are with the jurisprudence around fair use. And so I'm not hearing a whole lot of clamoring to do much in that area anymore, simply because I think they're comfortable with where the courts are.
Right, and I would largely agree with that. I mean, the interesting thing about U.S. copyright law is it's partly the statute, and certain parts of the statute are very, very clear, and then there's fair use, which it lays out these 4 factors about the purpose and character of the use and how much of the work is used and the effect on the market, etc. But what really matters is the case law,
right.
And judges are going to do what judges are going to do within these very broad standards laid out by the statute. So the interesting thing to me is really neither side of the debate is calling for any fundamental change in the way that fair use is adjudicated. No, I haven't seen someone even propose, say, oh, what we really have to do is, tweak the language of the first factor or the fourth factor or whatever. People sort of realize that this is all going to be fought out in, case after case, that it essentially establishes this body of common law, which is sort of how fair use gets sort of lived in this country.
Well, and that's how fair use was originally established.
Right.
And it wasn't until the 1976 Act that fair use was codified. So it's almost like we're going back to the old way of doing things with that. But it's interesting because what you just said about how there are no real calls on either side to update fair use. I think that's true of the statute generally, right? I mean, that's sort of a nice segue into our final slide here. Is that what's next? Well, we've had nearly going on 3 years now of conversation since Maria gave her speech at Columbia, and I think the resounding, the chorus of stakeholder voices is that there really is no interest in any kind of major statutory change. We've talked both today about some specific areas where statutory change may be warranted, but there really isn't a call for the next great Copyright Act. Nobody's really particularly interested in starting fresh with a brand new piece of legislation.
Yeah, no, I mean, Chris is absolutely right, and it's interesting. So several months ago, sort of I think it was just after the last hearing, it sort of wound down. I believe it was the Internet Association, which is the umbrella trade group that represents big players like Google and Facebook and Twitter, etc. They wrote a letter to the Judiciary Committee, essentially saying, what, we don't think that the time is ripe for major legislation. What we really think you ought to do is focus on Copyright Office modernization. And for our industry is generally not aligned with the Internet Association on copyright issues. We often take very, very different views. But we wrote a letter back, I think within a day or so, and said, Dear Mr. Chairman and Mr. Ranking Member, we just read this really interesting letter from the Internet Association that proposed that you focus on Copyright Office modernization. We said, we agree. So there's a sort of broad consensus, I would say, at least among the major institutional players, both on the sort of the pro-copyright side, the copyright owner side, and the user side, not to tear up the 1976 Act and start with a blank piece of paper, but instead, again, to focus on the Copyright Office modernization issue. We don't have full consensus yet on exactly what Copyright Office modernization means, but I really do think it's interesting that across the spectrum, I think the true answer is that everyone's a little bit nervous. I mean, no one loves the Copyright Act. No one loves every word and letter of the Copyright Act. Everyone would have their own pet things that they would like to tweak or delete or add, but they're more nervous about what would happen if you start over and rewrite it from scratch, because there's fear across the spectrum that it actually could turn out worse from their own perspective.
Yeah, and you can understand why the big institutional players have that position. They've built business models and structures over the years that are based on the current Copyright Act, and there's a potential that we'll end up with something that would require us to reevaluate all that, which would be expensive and time-consuming and a whole bunch of other negatives. But that sort of leads us to where we are now. So I already mentioned the PTO. We're expecting a white paper sometime in 2016. Don't know whether that's going to contain legislative recommendations, and an even bigger wild card, what Congress would do with the administration's recommendations in that space. Still don't really know where the Senate is going with all this. You heard Ben talk about the study that they commissioned from the Copyright Office earlier, but we don't know what's going to happen with that. I mean, presumably the office will do the study. Of course, we don't know what it will say, and we don't know if the Senate's going to take up any further interest in some of these broader issues, and including Copyright Office modernization for that matter. And then, is general legislation, you just heard us describing how there really isn't any support for overall legislation. I do think there's some room for them to do something in the music space. Obviously, modernization continues to be a hot topic. I also think small claims may be something they're going to try to tack on to the modernization piece, because that would require, if you do it the way the Copyright Office recommends, that it would be within the Copyright Office, and that would sort of part and parcel with whatever they do in the modernization space, I think.
And just to talk for a minute about Congress and sort of the politics of copyright. I mean, as I mentioned a few minutes ago, it's one of the few issues where there's really not a stark divide, or
Right.
there's really not any divide between Democrats and Republicans. I mean, major copyright owners have allies on the right and the left. I mean, both Chairman Goodlatte and a conservative Republican from Southwest Virginia, and the ranking member John Conyers, a liberal Democrat from Detroit, Michigan, both strong copyright backers. On the Senate side, I mean, you have people like Orrin Hatch, former chairman of the Judiciary Committee, a conservative Republican from Utah, strong supporter of copyright. Patrick Leahy, who's now the ranking Democrat on the Judiciary Committee, liberal Democrat from Vermont, big supporter of copyright. And again, and then there are those who are more skeptical of copyright on both the left and the right. This is really a non-partisan issue on Capitol Hill, almost unique among sort of major issues. But the interesting thing is sort of figuring out like what Congress is going to do here, if anything. There's one school of thought that says, you know what? Looking at Congress overall in the last few years, Congress doesn't do anything. They don't pass anything. There's complete gridlock. Copyright is just one more piece of one more area of legislation where they're not going to do anything. The other sort of school of thought, and I don't know which one is right exactly, is there's all these issues where Democrats and Republicans are at each other's throat, and that's the way. Republicans are never going to want to pass anything enacted that's supported by Democrats, and vice versa. So nothing gets done. Well, you know what? Here's this one issue where Democrats, and there's not this partisan split. There's coalitions of Democrats and Republicans actually on both sides of this issue. So maybe as opposed to taxes or immigration or abortion or any of those things which are, the parties are very starkly split, maybe this is something where the parties could actually come together and get something done.
Yeah, and I'm hearing a variant of that, which is that as we're recording this, we're heading into an election year, and that's the time when the parties don't want to be taking strong positions on or having conversations about some of those very divisive issues. Copyright is something that, unless you're a copyright lawyer or in the copyright world, people don't really care about too much, and so it's sort of like the time is now to do it if they're going to do it. So we'll see where things head in the next year or so on that front.
Right. So another one of these, one of the major players in the upper left and sort of the pro-copyright camp is the Copyright Alliance, and it's sort of an umbrella association that represents the Motion Picture Association, the major record labels, the book publishers, a lot of the sort of major industries. But it also represents a lot of the smaller copyright owners, individual graphic artists, photographers, songwriters, thousands and thousands of them. They actually have different interests from, in certain aspects, from the major copyright owners. But again, they're all very pro-copyright. In fact, there's if you talk to, say, songwriters in Nashville, there are, according to them, there's vastly reduced numbers of sort of everyday working man, working woman songwriters who are able to sort of make a middle-class living in in Nashville, sort of writing for country music. And Chris has particular interest in photography. Why don't you talk a little bit about sort of how this has affected sort of individual photographers?
Yeah, so same issue. It's getting harder and harder for photographers to make just your normal middle-class living. It's very difficult because the perfect storm. They're having major infringement problems because people are stealing their works left and right on the internet, and we jokingly call it the right-click license. The right-click save as, and then you've got an image. But that's going on with a bunch of issues in the industry as well, where the price points on stock photography have been depressed pretty dramatically. And I was just going to say, with the Copyright Alliance, it's interesting because they do represent both the big guys and the small guys. And just from my experience at the Copyright Office, they're very well respected. The Alliance is very well respected because of that. They have a very nice view of the entire ecosystem. And often, it's interesting because some of the big players and the little players are often at odds with each other. So the individual creators are frustrated with the large businesses that support them. And so it's a great mix of people, and their positions are often very well reasoned and very well thought out.
So, Chris, you were mentioning how sort of no one on any side of the copyright spectrum is now calling for sort of major reform, or really any kind of reform to the fair use doctrine. That wasn't the case several years ago. It used to be that a lot of those who participate in the debate who want a sort of weaker copyright system or stronger fair use were advocating for legislative change. Now, as you mentioned, one of the reasons for that has been developments in the case law. Most prominently, the Google Books case. It's called formerly Authors Guild versus Google. And I think it might be helpful to spend a few minutes talking about that. So essentially what the case is about is this. A number of years ago, Google decided it would be really useful to start a new service as part of its search services that it provides free to the public, to be able to search within the text of books. They weren't proposing that they make the full text of books available to everybody, but they wanted you to be able to sort of search within books and sort of get a little snippet where that search result appears. So if you were, for example, doing research and you wanted to know which books a particular term was used in or how often that term was used, you could search within books. Now, the problem is books are traditionally on paper and you can't sort of run a computer search on paper. So Google needed to get those books into its database. So what it decided to do was to go essentially copy or scan tens of millions of books, including books that are still protected by copyright. Scan those in. They had a very sophisticated automated process to do these, and would scan in millions and millions and millions of pages of text and use optical character recognition software and clean it all up and make these books searchable. Now, authors and publishers said, wait a second, you are making copies of our books. We are the copyright owners. We never gave you permission to do that. That's copyright infringement. This might be a socially useful purpose, but if you want to do that, you need to get a license and pay it for us and pay us. So initially, the large group of copyright owners on the book side, including both publishers and individual authors, and the Authors Guild representing publishers, brought a lawsuit against them in federal court in New York. And Chris, what happened in that lawsuit?
So the lawsuit. Well, I'll just cut to the chase. The lawsuit ultimately was found that use was fair, and it was following a tortuous path to get there, involving the Justice Department at one point brought an antitrust, or it wasn't actually an antitrust suit against Google, but they alleged that the settlement agreement that the parties had reached at one point, and I forget when that was, at 2009, I think, they reached a settlement agreement that basically would have turned copyright law, upside down and made it an opt-in, an opt-out. So basically, anybody who had published a book within a period of time was deemed to have given a license to Google. And the antitrust division said that gave too much power to Google and gave them a de facto monopoly over these books. So the settlement was fell apart. And then it resulted in this litigation, or continued litigation, where ultimately the court found that use was a fair use. And like I said, earlier, this is a substantial broadening, I think, of the fair use doctrine in a way that is not very palatable to copyright owners. And that's one of the other things that the Copyright Office is looking at, is ways of creating a license scheme for other players who want to do this. So if I want to set up my own book digitization service, is there a way I can get a single license in order to get permission to copy all of those books?
Right. So I should just say, as to the Google Books case itself, as we sit here in late November of 2015, the U.S. Court of Appeals for the Second Circuit just ruled a few weeks ago, affirming the summary judgment by the district court that Google's use is indeed a fair use. The Authors Guild has announced that they will seek review by the U.S. Supreme Court. They will be filing their cert petition sometime within the next couple months. So the case isn't final. There's a chance that the Supreme Court could take this up. They really haven't taken up a major fair use case in a couple decades. So there's some people are optimistic that the Supreme Court will take this up and maybe rein in the Second Circuit and sort of pull back on what is seen as a very expansive interpretation of the transformative use doctrine in the First Circuit. Traditionally, the transformative use doctrine talked about transforming the work itself. So if you take a work and change it and turn it into a parody, that's transformative. The doctrine has sort of shifted a lot over the last decade or so, where it's focused not so much on transforming the work, but on using it for a, quote, transformative purpose. So instead of sort of using the work just as originally intended, they might put it to a different work. And that's exactly what Google argues here, is they say, look, we're not making copies of the book just to read the book or to sell the book again. What we're doing we're making copies, but we're doing it for the entirely different purpose of creating this searchable database where you can't even read the book itself. But there's still a lot of debate between copyright owners and users and among academics over whether this transformative use doctrine has gotten completely out of control and sort of swallowed the rest of the factors. But so again, the Supreme Court may step in and clarify that. So over the last hour or so, Chris and I have been talking about things that have been going on the last 2.5 years, this copyright review process. Again, here in the late fall of 2015, the review phase of this whole process has basically wound to a close. And everyone's looking around now thinking what's going to happen next. And we don't know. We were at some of these roundtables, these listening sessions over the last few weeks, sort of kibitzing with members of Congress and their staff and the other representatives from across the spectrum, and everyone was kind of looking around and asking each other, what's going to happen now? What's going to happen now? And no one really has an answer. So I think members of Congress, members of the administration, members of the Copyright Office are sort of huddling to see sort of what their strategy is and what they actually want to know. And we're all looking forward to that.
Yeah, I think that's right. I think we've learned a lot about the Copyright Act and a lot about how people are engaging with the Copyright Act and building business models around it, but I think we've learned very little about what's likely to happen to the Copyright Act in the coming months and years ahead.
Right. So I'm Ben Sheffner with the Motion Picture Association. Thank you very much for joining us.
And I'm Chris Reed, Fox Entertainment Group. Thank you again for joining us.